Hello everyone! Welcome again to our channel. But before anything else, let me thank you all for watching yung part 1 until part 4 ng sale discussion and for patiently waiting for this part. Kahit na nga ang tagal bago kami makapag-upload. Your request, thank you messages, comments, and suggestions encourages us to really continue. Anyway, wag na nating patagalin pa kasi medyo delayed na nga rin. And so, tapusin na natin until Article 1488. Okay, so now let's proceed with Article 1484. In a contract of sale of personal property, the price of which is payable in installments, vendor may exercise any of the following remedies. First, exact fulfillment of the obligation should the vendor fail to pay. Second, cancel the sale should the vendor's failure to pay cover 2 or more installments. Third, foreclose the chattel mortgage on the thing sold if one has been constituted should the vendor's failure to pay cover 2 or more installments. In this case, he shall have no further action against the purchaser to recover any unpaid balance of the price. Any agreement to the contrary shall be void. Okay, so first, ano nga ba ang requisites para si Article 1484 may be applied? Okay? First, there must be a contract. The contract must be one of sale, di ba? Absolute sale. Not the one na meron pang right of redemption, okay? So, yung absolute sale talaga. So, what is sold is personal property. Kasi pag real property, Article 1484 is not the law that governs the sale of real property, okay? Ito, specific talaga, personal property lang siya, okay? Then, the sale must be on installment. So, if yung sale is in cash or yung may straight terms, including yung situation wherein magbabayad ngayon ng initial payment, tapos yung balance is paid in its totality at the time na na-specified, say after 3 months, then that is considered as cash. Okay? That is considered as a cash sale, and so Article 1484 is not applicable. Kasi nga, applicable siya in sale on installments. Okay? Now, ano ba ang purpose ng provision na to? It is actually to prevent the abuse in the foreclosure of chattel mortgages. Ibibenta sa mababang halaga and then after that, sisingilin mo pa rin for the deficiency yung buyer. Diba? Si buyer, nawala na nga sa kanya yung thing or yung property, tapos may utang pa rin siya na babayaran sa'yo ngayon. Diba unfair naman talaga? So, anyway, etong mga remedies na sinasabi ni Article 1484 ay alternative. They are not cumulative. Alternative meaning, if one is exercised, hindi na pwede yung iba pa. Okay? So, according to Article 1484, the seller has 3 options. Number 1, to exact fulfillment. Second, cancel the sale. And third, foreclose, diba? Foreclose the chattel mortgages. First, to exact fulfillment. This remedy is available when the buyer fails to pay one installment, okay? Kahit one installment lang. It is enforced through an action for specific performance or yung ordinary civil action for recovery ng unpaid balance. If he chooses this remedy, the seller is not limited sa proceeds ng sale. He can still recover from the buyer the unpaid balance, okay? But since yung nature nga ng mga remedies na to is alternative, hindi cumulative, then meaning If si seller chooses this remedy, hindi na siya pwedeng mag-avail ng remedy number 2 and number 3. Okay, hindi na pwede yung cancellation or yung foreclosure. Kasi yung pinili niya is to exact fulfillment. Now, eto namang second, cancel the sale. Kung sa una, parang pinipili mong pagpatuloy talaga yung sale. And so, naniningil ka lang ng payment. Dito naman, cancel the sale. So, cancellations ng sale, which is available from the time na si buyer fails to pay at least 2 installments, okay? This is usually enforced through an action for rescission of contract naman, okay? Although that is the usual way to enforce this option, hindi naman kailangan na yan talaga. Like yung nirepossess ni seller, he took possession of the thing again from that buyer. Sabi ni court, the said seller has chosen the second remedy. And so, he can no longer avail the other remedies, okay? Yung 1 and yung 3, which is exact fulfillment or yung sa foreclosure naman, okay? So, what would be the effect of rescission or cancellation ng contract of sale? First, dapat merong mutual restitution. Meaning, if si seller, he chooses cancellation, kailangan both parties must return whatever has been received by each of them. Okay? It creates an obligation to return the thing na object ng kanilang kontrata. Okay? Both parties, okay? They must return whatever has been received by each of them. Now, dito naman kay foreclosure, if si seller availed this third remedy, he exercised his right to foreclose the chattel mortgage. Klaro na rin naman kay Article 1484, he shall have no further action against the purchaser to recover any unpaid balance of the price. So, any agreement to the contrary shall be void. So, hindi na nga niya pwedeng ma-recover from the buyer yung unpaid balance. Okay? But note, dito, dapat mayroong actual foreclosure in order for the unpaid seller to be barred from electing the other 2 remedies. Okay? So, let's take an example para mas klaro yung provision na to. Kasi, for me, mas maiintindihan natin siya through an example talaga. So, eto. If si Pogi, binenta niya kay Ganda ang kanyang sasakyan worth 1 million pesos, payable in 12 equal installments, okay? Now, if Ganda defaulted in one of the installments, okay? Hindi siya nakapagbayad ng isa sa mga installments. So, question, can Pogi exact fulfillment of the obligation? The answer is, of course. Kasi di ba nga, kahit isang beses, sa remedies to exact fulfillment, hindi naman na-require na dapat merong magkaroon ng default in 2 or more installments. Dito, sapat na that the buyer fails to pay kahit 1 installment. Unlike doon sa option to cancel the sale. Okay? So, another question. Supposing if si Ganda failed to pay the first and the second installments. So, question, can Pogi exact fulfillment of the obligation? Yes, okay? Kung pwede nga siyang mag-exact ng fulfillment kahit isang beses lang na hindi nakapagbayad si buyer, of course, with 2 or more default, then all the more na pwede talagang mag-exercise ng remedy number 1 si seller or si Pogi in our example. Now, another question, can Pogi rescind or cancel the contract of sale? Yes, dahil Ganda fails to pay 2 installments, di ba? Yung first at yung second. And so, pwede talaga. Now, supposing if as a security, Etong si Ganda, nag-execute pala siya ng chattel mortgage on the car. Okay? And then, she failed to pay 2 installments nga. So, eto, question. Can Pogi foreclose the chattel mortgage? Yes, because Ganda fails to pay 2 installments nga. Now, eto, in the foreclosure sale, the sum that is obtained by Pogi, okay, yung nakuha ni Pogi na pera sa foreclosure sale is less than what Ganda owed him, okay? Say, example, nung binenta niya into a foreclosure sale yung sasakyan, ang nakuha niya lang is 800,000 pesos. So, can Pogi still collect the deficiency? So, the answer is no. Even if there is a stipulation na pwede pa niyang makuha yung unpaid balance, hindi na talaga pwede because the stipulation is void. This is the provision of directo law. Okay? So, another question is, when can Pogi recover the deficiency? If he will not foreclose, okay? Instead, he file an action as an ordinary creditor. Tapos doon, pwede niya ma-recover yung balance. Let's take another example. Ito. If, yun pa rin. Okay. Anyway, similar situation. Si Pogi, binenta niya kay Ganda ang kanyang sasakyan worth 1 million pesos. Tapos, si Ganda executed a chattel mortgage, okay, as a security for the payment of the purchase price. Now, after that, si Ganda consecutively fails to pay 3 consecutive installments. Okay, hindi siya nakapagbayad ng 3 buwan. And so, si Pogi nag-file siya ng complaint against Ganda to recover the unpaid balance. A writ of attachment was subsequently issued against the property. So, thereafter, yung sasakyan ni Pogi was sold at a public auction. Now, after nung public auction, nagkaroon pa rin ng deficiency na, say, 200,000 pesos kasi nabenta lang yung sasakyan ng 800,000 pesos. Since merong deficiency, the court ordered Ganda to pay Pogi the deficiency plus yung interest pa. Question, is this ruling in accordance with the law? Okay ba? Tama ba yung ginawa ng court? Yes. Dahil hindi naman finorclose ni Pogi yung mortgage property. Okay? And so, therefore, the deficiency is recoverable. Okay? The answer would be different. Iba sana kung yung ginawa ni Pogi is nag-file siya for foreclosure. Okay? He opted to foreclose the chattel mortgage. Pero dito, hindi. Nag-file siya ng action as an ordinary creditor. Okay? So, that's it. That's Article 1484. Sana nga malinaw. Although, ewan kung nakatulong. Kasi parang magulo. Anyway. Sige na, Article 1485. The preceding article shall be applied to contracts purporting to be leases of personal property with option to buy when the lessor has deprived the lessee of the possession or enjoyment of the thing. So this is a situation wherein yung lease is construed as sale. Kahit pa nga yung word na lease yung ginamit, pero makikita na rin naman natin that it is a sale on installment, then it would be construed as sale. Hence, etong rule under Article 1484 will also be applicable. Okay? So, yung purpose talaga ng provision ng Article 1485 is to prevent indirect violation ng Article 1484. Okay? So, Article 1486. In the case referred to in 2 preceding articles, a stipulation that installments or rents paid shall not be returned to the vendee or lessee shall be valid insofar as the same may not be unconscionable under the circumstances. So, as a general rule, pag cancellation or recession, it requires mutual restitution, meaning yung partial payment of price must also be returned. Pero as an exception, pwede na hindi ma-return, okay? If merong valid stipulation, nasa usapan na there will be no returning of the price that has been partially paid. Article 1487. The expenses for the execution and registration of the sale shall be borne by the vendor, unless there is a stipulation to the contrary. So, as a rule, si seller. Pero pwedeng magkaroon ng contrary stipulations, okay? Simple as that. Let's not waste our time with this article. Let's proceed with Article 1488. Now, the expropriation of property for public use is governed by special laws. So, yung expropriation is involuntary in nature kasi, di ba? Yung owner was compelled to surrender the property after makomply ang mga requirements. So, generally, hindi talaga siya sale. Okay? Yung expropriation is hindi sale dahil nga, by nature, hindi naman talaga siya voluntary. Yung sale, voluntary naman yun. Eto, involuntary na in-expropriate sa kanya yung property. And so, it is governed by that law, hindi ng law of sale. Okay? So, yun yung ibig sabihin ni Article 1488. Unless the property owner, binenta niya kay government yung property niya voluntarily. So, yun, sale siya. Okay? So, that's it. That ends our discussion sa nature and form ng contract of sale. Yung next video would be on the capacity to buy and sell. So, thank you for listening. And then, pasensya kasi medyo natagalan talaga. Anyway, if you find this video helpful, please like and subscribe and click that notification bell para updated nga kayo sa new video uploads namin.